Thank you to the organizer for opportunity to present you children's rights in Romanian private law. In this presentation, I will mention the most important elements of the topic. The published article contains many more aspects than those presented. Children's rights are human rights, prerogatives that the European Union and its member states must respect, protect, and guarantee. 35 years have passed since the United Nations Convention on the Rights of the Child was signed in New York in 1989, a regulatory document which came into force in Romania in 1990. The analysis of the rights of the child in Romania is intended to assess the impact of national legislation on the rights of the child and aims to present, in general, the means of private law by which the interests of the children are protected and promoted. Regarding concept of families, the concept of family is not generally defined by the Romanian legislator. However, one meaning of the concept of family can be found in the provisions of the Civil Code, which states that the family is based on the freely consented marriage between spouses, on their equality, and on the right and duty of the parents to ensure the upbringing and education of their children. From the Romanian regulations, it can be concluded that the family is understood as that form of organization of the lifelong union of the group of persons between whom there are rights and obligations arising out of marriage, kindred relationships, and other relationships similar in some respects to family relationships. The European Court of Human Rights ruled in relation to family life when it was found to be violating Article 8 of the Convention. In this ruling, the Court has extended the concept of family to include grandparents and, in some cases, the cohabiting partners, therefore the persons who form a family outside marriage. Thus, for example, in the case of Marquis versus Belgium, it was stated that in the eyes of the court, family life within the meaning of Article 8 encompasses at least the relationships between parents, relatives, who can play a considerable role, for example, between grandparents and grandchildren. In Schark and Koff versus Austria case, the court, in its judgment, noting that the attitude of society towards homosexual couples had changed rapidly in many European Union member states, considered that it was necessary to review its previous case law, according to which homosexual couples did not enjoy the protection of family life, but only that of private life. In this respect, the court held that insofar as the national law does not provide for the possibility of legally establishing of such a union, this leads to a violation of Article 8 of the Convention on the Protection of Family Life, in conjunction with the Article 14 of discrimination by reference to heterosexual couples. In other words, the court held that although states are not obliged to regulate same-sex marriage. In conclusion, the case law of the ICCR, established in application of the Article 8 of the Convention, highlights the obligation of states to respect family life in the broad conception of family relationships, and this creates a valuable bridge between the family life in the legal sense and the family in the sociological sense. Regarding legal capacity of the child, according to the provisions of the Civil Code, the capacity to have rights and obligations begins at birth. Therefore, the date of birth of the child is the moment when the child acquires the capacity to have rights and obligations, which is usually a certified date. This date is important in many ways, both theoretically and practically. From the date of birth, we can speak a new subject of law, with the capacity to have civil rights and duties. The exception relating to the acquisition of the capacity to have rights and obligations of the natural person has its legal basis in the provisions contained in the civil code, according to which the rights of the child are recognized from conception, but only if the child is born alive. In this respect, with regard to the capacity of the natural person to inherit, the civil code states, a person may inherit if he or she exists at the time of opening of the inheritance. Regarding legal capacity to act, minors under the age of 14 do not have the capacity to act because they are considered to lack the necessary discernment to participate in the legal life because of their young age. The lack of capacity to act of a minor under 14 years is justified by the fact that he or she does not have yet the necessary discernment to foresee the consequences of his or her action to enter into civil legal acts by himself or herself. The legal deprivation of the capacity to act for this category of minors constitutes a protection measure in order to prevent them from suffering as a result of legal acts that are unfavorable to them. Regarding legal representation of children who lack the capacity to act, the Article 45 of the Civil Code states that for those who lack the capacity to act, the legal acts are concluded on their behalf by their legal representatives under the condition provided by law. But who are the legal representatives referred in the article cited? Article 501 of the Civil Code states, parents have the rights and duty to administer the estate of their minor child, as well as to represent him or her in civil legal acts or to approve these acts, as the case may be. In cases where, for certain reasons, the legal representation by the parents is lacking, it shall be carried out by the guardian, a rule laid down in the Civil Code which states the guardian has the duty to represent the minor in legal acts, but only until the minor reached the age of 14. Regarding legal acts may be concluded validly by the minor lacking the capacity to act, according to the Civil Code, there are two acts may be concluded validly by the minor, acts of preservation, aimed at preserving a right or preventing its loss, such as summons, sealings, registration of mortgage in the publicity register, and act of disposition of small value of a routine nature, which is necessary to satisfy the basic ordinary needs of life, that is, the small everyday necessities. Such acts are ordinary shopping in stores, buying tickets for a show, buying school supplies, sweets, for example. Regarding restricted capacity to act of a child, the restricted capacity to act of a natural person in Romania means the capacity of a minor between 14 and 18 years of age to acquire and exercise subject civil rights and to assume and exercise civil obligations by personally entering into civil legal acts with the prior consent of their legal guardian. Regarding personality rights of the minor, the Law 272/2004 on the protection and promoting of the rights of the child is the statutory act that also regulates the rights of the personality of the child in Romania. In this sense, there are following rights of personality of the minor. The child has the right to establish and preserve his or her identity. The child ID registered immediately after birth and from that date has the right to name, the right to acquire a nationality, and if possible, to know his or her parents and to be cared for, brought up and educated by them. The child also has the right to the protection of his or her public image and of his or her intimate, private, and family life. The child has the right to freedom of expression, and also a child belonging to a national, ethnic, religious, or linguistic minority has the right of his or her own cultural life to declare his or her ethnic, religious, and religious affiliation, to the practice of his or her own religion, and to use his or her own language jointly with the other members of his or her community. Also, the child has the right to respect for his or her personality and individuality and shall not be subjected to physical punishment or other humiliating or degrading treatment. Regarding the right of inheritance of the minor, a minor child can acquire the status of heir and respectively accept on inheritance through a trustee appointed by order of the guardianship authority of the town hall of the minor's place of residence or by order of the family court. According to the civil code, in Romania there are two types of inheritance, legal and testamentary. As long as a person is alive at the time of the opening at the inheritance, he or she can inherit from a relative or the person who mentioned him or her in the will. Regarding adoption procedure, adoption is the procedure whereby an adult legally takes custody of a minor child and assumes the rights and responsibilities of the child's natural parents. In order to be adopted, a child must be registered with the authorities, and once adopted, the state will look for a family. The adoption in Romania is governed by Law 273/2004 on the adoption procedure. Families and single persons are eligible to adopt a child. In contrast, two people cannot adopt a child together, either simultaneously or successively, unless they are husband and wife. At the same time, persons who suffer from mental illness or have a mental disability, those who have been definitively convicted of a crime against the person or the family committed with intent for human trafficking or trafficking and illicit drug use, or those who have been deprived of parental rights or who have a child under special protection, cannot adopt a child or children. Matching criteria are the age, gender of the child, number of children the family can care for, health status, and level of development of the child. If all goes well, the matching report shall be drawn up at the end, and if the child is to be accommodated with the adopted family or persons, the Directorate General for Social Welfare and Child Protection shall refer the matter to the court for the child to be placed for adoption. Regarding self-determination in matters of health, Law 95/2006 on healthcare reform established the minimum age of 18 years for the informed consent. But what happens when the patient is a child? In case of minors, informed consent is given in their name and on their behalf by their parents or legal representative. However, by way of exception, minors may express their consent in the absence of their parents or legal representatives in emergency situations when parents or legal representatives cannot be contacted, and the minor has the necessary discernment to understand the medical situation in which he or she finds himself or herself, in our opinion, after reaching the age of 14. In the case of a minor who lacks the capacity to consent, account shall be taken of the fact that an intervention may be carried out only for his or her direct benefit and only with the authorization of his or her legal representative and authority another person designated by law. The opinion of the minor shall be taken into account as a determining factor in relation of his or her age and level of maturity. Per contrario, the doctor, nurse, or other competent healthcare professionals are legally liable when they have not obtained the informed consent of the minor patient or his or her legal representatives, except in case of emergency when the child's legal representative cannot be contacted. In this situation, the guardianship authority may be asked to authorize the medical procedure or, as the case may be, the act without consent in emergency situation when the time interval taken to obtain the consent would endanger the health and life of the minor or of other persons. Regarding the rights and conditions of the child at work, in line with the European standards Romanian law imposes strict conditions on the employment of minors. The common and binding general provisions in Romania concerning the employment of minors are: the minimum age at which a minor can be employed is 16. It is permitted to employ adolescents aged 15 years or over, but only with the consent of their parents or legal guardians. The employment of persons under the age of 15 is prohibited. Minors who have reached the age of 16 years do not need the consent of their parents or guardian. The adolescents are employed under an employment contract. The length of the working day is a maximum 6 hours per day and a maximum of 30 hours per week. Minors may not perform work that is hazardous, unfit for their age or physical abilities, or work at night. The wage must be at least the minimum wage with a maximum of 30 hours of work per week. In our conclusions, we can affirm that the rights of the child in Romania tend to be satisfactorily ensured, but we believe that the future improvements of the legislation must be adjusted in relation to the best interest of the child. Furthermore, it is necessary to develop the training process of specialists who work with children and for children to ensure that the principles of the best interest of the child is clearly understood and correctly implemented. Thank you for your attention.